Most states allow for a parent to disinherit a child. Those that do not still allow for partial disinheritance. Whether fully or partially disinherited, a child may still have rights to their inheritance. The key is to prove the child was disinherited for unjustifiable reasons, such as the parent lacked capacity when they disinherited the child, the parent was unduly influenced to disinherit the child, or the parent was not allowed to disinherit the child from the trust created by a deceased parent. Let's explore these things. Is it legal to disinherit a child? In most states, it is legal to disinherit a child for any reason or no reason at all. In some states where forced heirship laws still exist, a child may only be partially disinherited. Regardless of the level of disinheritance, a child may only be disinherited by a parent with capacity, acting without undue influence, meaning they are of sound mind and acting of their own free will. What's more, if the parent is disinheriting a child for some reason, that reason needs to be factually accurate. Finally, to disinherit, the parent must have the authority that the will or trust document through which they are disinheriting the child provides. How can a child fight disinheritance? While it may not necessarily be illegal to disinherit a child, there are several claims that a disinherited child may be able to pursue to seek recovery of their rightful inheritance. First, undue influence or duress. If a child is disinherited as a direct result of undue influence committed by an abuser, then the disinherited child has a legal case to claim their rightful estate assets. An example of undue influence could be a step-parent withholding sexual relations or affection from the child's parent unless the child is disinherited. Another example is threat of physical violence or threat of removal of care services by a child against a parent unless the child's sibling is disinherited. We often see lack of mental capacity or even physical capacity, which creates the opportunity for the abuser, coupled with undue influence or duress claims. Second, mental incapacity. If it can be demonstrated that the parent was not of sound mind when they disinherited the child, then the disinherited child has a legal case to claim their rightful estate assets. An example of mental incapacity could be a parent suffering from cancer who is heavily medicated, or a parent who is schizophrenic and suffering from delusions. It is critical that the mental issue occur at the time the child was disinherited and that it impacts the parent's functional ability to make the decision at issue. Third, mistake of fact. If it can be shown that the parent disinherited the child due to a reason that can be proven untrue, for example, the child was believed to be a drug addict, then the child may be able to invalidate and avoid the disinheritance. These claims most commonly are coupled with undue influence, duress, and incapacity claims, where a parent is frail and influenced by a step-parent or other child or caregiver to disinherit the child for reasons that are not true, but the parent is made to believe are true and cannot appreciate that they're not true. For example, a caregiver telling a parent with Alzheimer's that the child never visits, doesn't care about the parent, and that the caregiver is the only one who cares for the parent. Therefore, the parent should disinherit the child and give the caregiver the entire estate. Fourth, lack of authority. Often a parent will overstep their ability to disinherit a child and attempt to disinherit the child not only from the portion of the estate the parent owns and controls, but also from the portion of the estate that their previously deceased partner and spouse owned and left for the child. The majority of estate plans provide that after the first parent dies, their share of the estate becomes irrevocable, meaning that it cannot be changed by the surviving spouse. Most surviving parents don't realize this, and either of their own volition or in combination of being unduly influenced, and try to disinherit the child from their and their deceased spouse's shares of the estate. Because the plan was irrevocable and could not be changed, they can't do that with regard to the deceased spouse's share. What are the legal rights of a disinherited child? A disinherited child has the legal right to receive a copy of the document that purports to disinherit him or her. A disinherited child also has the right to challenge the purported disinheritance for any of the reasons we discussed previously. The key here is to consult a probate litigation attorney or trust litigation attorney early to ensure that key deadlines aren't missed. How much inheritance can I get? If the cause of the disinheritance was the result of undue influence or duress, mental incapacity, mistake of fact, or lack of authority, we commonly see the disinherited child receiving a substantial portion of the inheritance they would have been entitled to receive prior to the disinheritance. It all depends on the relative strengths and weaknesses of your case. That's why it's important to consult a probate litigation attorney or trust litigation attorney early so that we can help determine whether your case is worth pursuing and what the likely outcomes may be, as well as the cost and timeline. In many cases, we've been able to recover and help heirs and beneficiaries get 100% of their inheritance, and often only in a few months. The key, again, is to start early with counsel, dig deep, and initiate court processes so you have a mechanism to secure a resolution or take the case to trial. How can a disinherited child contest a will or trust? Contesting a will or trust is fairly common and straightforward. In fact, every day, tens of thousands of disinherited children and other beneficiaries contest wills and trusts seeking their rightful inheritances. The key is to gather the important documents, for example, the will or trust that disinherits you, along with earlier versions of those documents, if any, along with key facts, and consult counsel early. A proven probate litigation attorney can help analyze the documents and the facts of your case and tell you whether you have legal recourse, what the likely outcome may be, how long it will take, and how much it will cost. How much does a probate litigation attorney cost? Probate litigation can be expensive, but many lawyers, like here at RMO, offer alternative fee arrangements, including contingent fee and hybrid fee arrangements. Don't let your fear that you can't afford it deter you from taking advantage of a free consultation with someone who might be able to help you. What should I do if I think I was disinherited unjustifiably? Well, you should contact a probate litigation attorney the moment you discover you are disinherited. Do I need a probate litigation attorney near me? We recommend finding an experienced probate litigation attorney familiar with the county probate court in the county where the decedent lived. For example, if the decedent lived in Los Angeles, we recommend working with a probate litigation lawyer familiar with the Los Angeles probate court division. They'll be more familiar with the judges, the processes, than someone from outside the area. At RMO, we help people like you address issues like these every day. Have questions? Give us a call or shoot us an email. The consultation's always free. Thanks for watching.